This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law's Intellectual Property Review. I'm Josh Block. Last week, Stephen Colbert, on his Comedy Central show, recorded two segments on SOPA, the Stop Online Piracy Act. Many tried to find those segments on YouTube, but instead found last week's episode of this podcast and our discussion of SOPA that mentioned Colbert. One of the reasons you won't find Colbert on YouTube anytime soon is because Viacom, Comedy Central's owner, and Google, YouTube's owner, are engaged in a court battle that could determine who has the burden of finding infringing videos on websites like YouTube, but also Facebook and Twitter, that depend on user-generated content. As debate continues over bills in Congress intended to combat online piracy and intellectual property theft on the internet, a court battle continues over the law that we do have that deals with copyright infringement on the internet, the Digital Millennium Copyright Act, or the DMCA. The safe harbor provisions of the DMCA shield a service like YouTube from liability for copyright infringement, but they are also the basis of the lawsuit. Viacom is seeking approximately $1 billion in damages from YouTube. The case will give greater clarity to what is allowed under the DMCA's safe harbor provisions. I'm joined now by Bloomberg Law's intellectual property product manager, Michael Dunn. Michael, what is the intent of the safe harbor provision of the DMCA?
The safe harbor provisions, and there's actually a number of them. The one that's applicable in this instance is the safe harbor provision for storage of content that is initiated by a user. The intent behind the safe harbor is, it was basically Congress's intent to protect emerging internet business models. This law actually dates back to 1999. So Congress sort of was taking at that time a hands-off approach to a lot of internet regulation. So the safe harbor protections were intended to sort of satisfy the technology lobby at the time by allowing them to basically take advantage of this harbor that shields them from liability for content that's uploaded by their users, as long as they comply with the rest of the provisions of the DMCA.
This case dates back to 2007. What was going on then, and how did the service work then? And how did the
way YouTube works in compliance with the Digital Millennium Copyright Act is what's known as the notice and takedown procedure. And that means that YouTube has designated an agent to receive notices under the DMCA, and essentially any copyright owner who feels like his or her copyrights have been violated by content that's stored on YouTube will file a notice with YouTube's DMCA agent. You know, there are specifications in the DMCA itself for what that notice has to contain to be effective. So they have to identify the particular piece of infringing content. They have to specify that they own the copyright on it. And then once that's filed, YouTube will comply with that takedown notice and take down whatever infringing content is up. And then there's a whole counter notice procedure. The idea would be if YouTube complies with that procedure, then theoretically it would be shielded from liability for this content by the safe harbor of the Digital Millennium Copyright Act. Now, no one really disputes that that's how YouTube operates and that it does have a DMCA agent and it does comply with takedown notices. What's actually sort of motivating this particular dispute is another provision of the DMCA safe harbor that basically says the safe harbor is not available in instances where the service provider is aware of facts or circumstances from which infringing activity is apparent. And this text has become known as the red flag provision, basically saying if there are red flags that infringement is taking place, the provider may not be able to take advantage of the safe harbor. So the dispute between YouTube and Viacom is over what that red flags provision means and whether or not YouTube, who was complying with the notice and takedown procedure, is also in compliance with this red flags provision or not.
In the case, the court has asked for post-oral argument briefs. They're asking for further explanation from YouTube and from Viacom what's expected with this red flag knowledge.
That's right. The lower court dismissed the case on summary judgment. It said YouTube complied with the DMCA, so it was protected by the safe harbor, and there was no liability. And Viacom obviously appealed that dismissal, and so there's been oral argument before the Second Circuit, and in a sort of rare step, the Second Circuit has actually gone back to both YouTube and Viacom and asked for supplemental briefing specifically on the issue of whether or not what the red flags provision means. And basically under YouTube's interpretation of the red flags provision, which is that there still has to be some knowledge of specific infringing activity, how that exist in the statute with the regular notice and takedown provision. So basically what this red flag provision means and how it should be interpreted with respect to YouTube's business model is the issue that is being discussed right now.
Viacom is arguing that the knowledge goes beyond specific knowledge, that red flag knowledge is something different.
Viacom's arguing that a generalized awareness that there is infringing activity on the website triggers a requirement on the part of the service provider to investigate, and to the extent that it finds actual infringement, to move expeditiously to remove that infringement from the system. And they're saying that's how it's distinct from the notice and takedown provision, which requires the owner, in this case Viacom, to actually give specific notice of infringing files. Viacom's saying if this red flags provision meant that there still had to be a provision of specific notice, it would just be duplicative of the regular notice and takedown procedure. Now, YouTube, on the other hand, is arguing that the red flags provision is slightly different. It still requires a plaintiff to provide to prove that the service provider is actually aware of facts from which a particular infringement would have been apparent to a reasonable person. So YouTube is making a sort of subjective-objective distinction in the sense that with the notice and takedown provision, there has to be an objective notice that a specific file is infringing. With the red flags provision, YouTube is saying there still has to be specific knowledge that would have the service provider have a subjective knowledge that there's infringement taking place. So YouTube is still saying there has to be specific knowledge of infringement, but it's sort of a difference as to whether it has to be a subjective knowledge or an objective knowledge.
There's a second issue that's being argued, and that's over syndication. Can you explain what that means?
Syndication, in this sense, is just the way that the parties are referring to YouTube's business model that allows it to, for example, have files viewable on mobile phones or have files viewable through any other sort of mobile web or TV web product. According to YouTube, they have to do certain things to those videos in order to make them work with these different types of internet models. So they have to process the videos in one particular way to have them viewable by most web browsers, but then they have to process the videos in multiple other different ways to have them viewable on the mobile web or on internet TV. Viacom's argument is the safe harbor only extends to storage of content that is uploaded by a user, and they're saying the fact that YouTube has taken all these actions on the videos once they're uploaded in order to make them compatible with various different types of web business models means that they're actually doing something to the videos themselves that would take them outside the realm of the safe harbor.
The implications of syndication, as Viacom describes it, those implications could be vast.
Yeah, essentially it would mean YouTube would be basically prohibited from modifying these files in any way so that they could be viewed on your mobile phone or on your TV unless they have an agreement with the content owners to do so. Now, keep in mind, a lot of these videos haven't been uploaded by the content owner. They're quote-unquote infringing. So YouTube would essentially, if Viacom's interpretation was correct, YouTube could be liable even though it didn't intend to modify Viacom's content for mobile web, and it instead modified all the content on its system, and it didn't actually know or didn't actually take into account that it could be Viacom's content that's been uploaded unauthorized. YouTube could still be liable for that.
Does the fact that the court asked for briefs after the oral argument, indicate anything?
It's an interesting question, and I don't think we know the answer. At the very least, you would think that it indicates that the judges on the Second Circuit that are hearing this dispute are sort of confused on these 2 points, or wanted a more fulsome discussion of where the parties stand on these 2 points that wasn't raised in the actual oral arguments.
At the center of this is who bears the burden of policing piracy. Is the DMCA enough? Do we need new laws? Where are we with this?
Well, that's exactly the gist of the dispute. I think defenders of YouTube's behavior in this case would say, and YouTube itself would say, look, the DMCA is working perfectly in this instance, right? Any video that sits out there that is infringing, all Viacom has to do is let YouTube know that this infringing video is uploaded. And YouTube's argument is, look, it has no way of knowing one way or the other. It receives the video uploads from users. They appear on the website. It doesn't have a way to determine who the actual copyright owner is. It doesn't have a way to determine whether or not all these videos were uploaded with or without authorization of the copyright owner. And then it doesn't have a way to determine if there's any fair use defense as to whether or not copyrighted material should be able to be uploaded in a user video. So YouTube's argument is it's just not capable of making those distinctions or doing that sort of study. And, it would point to things that are actually in the record in this particular case, where, for example, Viacom employees themselves uploaded videos to YouTube and deliberately tried to make it look like someone else was uploading it to create sort of a viral video effect and take it away from the appearance of marketing. And also, it came out in this dispute that Viacom had no idea whether it had authorized videos to be uploaded or not. So YouTube points to that and says, well, if Viacom doesn't even know what it's uploaded and what's authorized and what's not authorized, how in the world would we, YouTube, know, right? And so Viacom's response to that is, look, YouTube knows, and there's evidence that it knows, that a certain percentage, a very large percentage of content that's loaded onto YouTube is actually infringing content. There are memos from the founders before the sale to Google sort of laying out the fact that a very large percentage of some of their revenues, or their advertising revenues, or their page hits, is actually derived from infringing content for which they don't have authorization to display. So Viacom is saying there simply has to be some other method for evaluating what YouTube is allowed to display and what they're not, because otherwise Viacom would have the thankless and, almost impossible task of going through millions and millions of videos that are uploaded to YouTube every day to determine which ones are Viacom videos.
If the court came out in favor of Viacom, would it in effect do what they're hoping will be done through legislation?
It will do a part of it. Most proponents of the Protect IP Act and the Stop Online Piracy Act would argue that the main purpose of those acts is to target foreign websites that are infringing U.S. copyrights. But there is, at least in the Stop Online Piracy Act, there is a pretty clear provision that seems designed to target U.S. websites, to cut off the business models for sort of rogue U.S. websites that are dedicated to the infringement of intellectual property. You could see a scenario where Viacom could make an argument under the Stop Online Piracy Act as drafted that YouTube is a rogue website targeting to infringement, and they would point to, the thousands and thousands of infringing files on YouTube and potentially seek to get, payment processors and internet advertisers to stop doing business with YouTube. Now, whether or not this lawsuit would accomplish that same thing, actually it seems like this lawsuit would even go further than that, in that if Viacom is successful in this suit, YouTube could be liable for all of this copyright infringement. So it's not even just a matter of trying to mess with their business models. It's that YouTube would be liable to Viacom, in here for $1 billion or some variation thereof, for content that's uploaded by users that, and one would assume going forward, YouTube would be expected to put in some sort of monitoring system. And how that monitoring system would work and what it would actually require YouTube to do is sort of the big open question here. One would assume that whenever there's a system in place that would require a service provider like YouTube to determine whether or not a video is infringing or not, that service provider is going to err on the side of suppressing content to keep itself from facing liability. So one would assume that you would have a much larger swath of even arguably fair use content that's going to be suppressed under a scenario like that.
I had read in an article published in BNA that the issue that Viacom has is with the procedures prior to 2008, and that now their procedures are better.
That's right. YouTube has implemented some digital fingerprinting and other types of techniques in order to sort of more proactively identify infringing content, and they've also allowed some content owners to sort of take a more active role in how they notify YouTube of infringing content and how the takedown actually happens.
That point even goes to the syndication issue.
That's case. Right. YouTube made some changes in around 2007, 2008 to who and which user-generated content actually is available for syndication to other formats like the mobile web and internet TV. So, for example, now someone who uploads content to YouTube has to agree through YouTube's terms of service to allow the content to be syndicated, but they can also prohibit. So they can refuse to allow the content to be uploaded, and you'll see that a lot if you use YouTube a lot to look at sort of videos that are authorized by your big content companies like your Viacom. You'll often get a notice if you're trying to view it on your phone, or if you're trying to look at it embedded in a website, you'll see a notice saying that you actually have to go to the YouTube website itself to see this content, and that message is produced because the content owner has told YouTube essentially not to syndicate this video.
Last week, I also asked you about the effect that SOPA could have on new websites and on websites that exist. But similarly, with this, if it were to come out for Viacom, websites that depend on user-generated content may not have the opportunity to start, and there may be a real effect on YouTube, Facebook, and Twitter.
That is right. Facebook, Twitter, all the social networking websites that allow content to be uploaded by their users would have to grapple with the ramifications of a decision in favor of Viacom in this dispute. And this isn't the first time these issues have come up. This is the most notable instance, and it's the first time the Second Circuit has actually looked into this issue. But there are other court opinions that have agreed, in essence, with what the lower court did here and said, look, the notice and takedown provision is essentially what the DMCA prescribes. And if you import this red flags rule in the way that Viacom has interpreted, it sort of eats up the notice and takedown provisions altogether, right? Because if you have some knowledge that there's some infringement on your site, well, then there's no longer any need to have a specifically crafted notice that complies with the DMCA, because under the red flags provision, that service provider would be required to proactively screen for infringement. So there is a lot of concern among those communities, and you're right, it could have a definite impact on new companies entering the space. I mean, how are you going to get to the level of a YouTube if you're going to face crippling liability from the onset because of content that's been uploaded by users?
That's Michael Dunn. You can find out more about the case Viacom v. YouTube at BloombergLaw.com. You can find new IP podcasts each week at Bloomberg.com/podcasts. You can subscribe at both YouTube.com/BloombergLaw and on iTunes. Thank you for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained